It's the same thing that I say to everybody. If you can't follow the rules in jail, then it doesn't give me a lot of confidence that you're going to be able to follow the rules on probation. Good morning. Are you Ray Leblanc? Can you hear me okay like that? Okay. And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. LeBlanc, in cause number 250460, you're charged with the state jail felony offense of burglary of a building from February 5th of 2025. How do you plead to that charge? Are you pleading guilty freely and voluntarily, and because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them?
This opening exchange moves fast, but there's a lot happening legally behind the scenes. The judge is making absolutely sure the plea is voluntary and informed because once a defendant signs a plea agreement like this, reversing it later becomes incredibly difficult. And notice that phrase, waiving the right to appeal. That's huge. In exchange or a negotiated sentence, the defendant is basically agreeing not to challenge the outcome later unless something extraordinary happened. Do you think most defendants fully understand how permanent that decision can be in the moment?
With Ms. Holmes.
Yes,
Do you fully understand them?
yes,
Do you understand if I follow the agreement that you made with the district attorney that you will be waiving or giving up any right to appeal?
yes,
And are you a U.S. citizen?
yes.
You're a U.S. citizen.
Oh, yeah.
Okay. I have to ask everyone. State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. LeBlanc is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. And at this time, find you guilty of burglary of a building. Sentence you in accordance with your agreement to a term of 6 months in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows that this was an agreement that I followed, so you've waived your right to appeal. I am also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition.
Okay.
Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices. I'm required to read it to everybody.
I've never owned a firearm in my life.
I got to say all these words, sorry. So you should read that to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk to Ms. Holmes. Good luck to you, sir. Thank you, Ms. Holmes.
Yes, ma'am. Thank
Jubert.
Yes, ma'am.
And Mr. Jubert was previously in court, entered pleas of guilty in cause number 25 DCCR 1130 to unauthorized use of a vehicle, a state jail felony, and in cause number 25 DCCR 1131 to the third degree felony offense of evading arrest or detention with the use of a vehicle. I've received that pre-sentence report. Has everyone had an opportunity to review it?
You have, Judge.
I have. Are there any additions or corrections?
No, Judge, not at this time.
Only that the state concurs with the recommendation of the ISF cognitive judge.
All right, thank you, Ms. Malfino. All right, Mr. Jubert, I am so, Mr. Jubert, I know you know this already because everybody out there knows that I get the jail reports, right?
Yes, ma'am.
So there was an issue pretty recently. You haven't had a lot, but just recently you had earlier this month one about a mattress, right?
Yes, ma'am.
And you weren't very respectful about what you said to that.
This is one of those moments judges care about way more than people realize. The mattress incident may sound minor, but to the court it's a test of behavior under structure and supervision. Probation only works if someone can follow rules consistently, even small ones, and the judge is connecting the dots directly. If you can't handle jail rules, why would the court trust you outside jail walls? That warning wasn't casual at all. It was basically the judge saying, you're already on thin ice.
Officer, when they said for you to give up one of those mattresses, were you?
Yes, ma'am.
So it's the same thing that I say to everybody. If you can't follow the rules in jail, then it doesn't give me a lot of confidence that you're going to be able to follow the rules on probation. Does that make sense?
Yes, ma'am.
So part of this agreement, or part of the recommendations in this agreement, is for me to go along with giving you probation, but send you to the ISF program, the cognitive track, which is a program to help you make better decisions. But I want you to understand, if I follow along with this agreement and you get any more incident reports, either here or at ISF, it's going to be a violation of your probation, and you may never get out of jail before you violate it. And I know you've been out there long enough to know that I've done that already, right?
Yes, ma'am.
Okay. So then what I'm going to do, Mr. Jubert, is give you this opportunity. I'm going to find in each of your cases that you entered those pleas freely and voluntarily. In cause number 25, DCCR 1130, find sufficient evidence to find you guilty, but I'm going to follow the agreement, defer all proceedings, place you on probation for 5 years. You're ordered to pay a $500 fine in that case and to follow all of the rules and conditions of probation. And then in cause number 25, DCCR 1131, also find sufficient evidence to find you guilty, but follow the agreement and defer all proceedings for 5 years. You're ordered to pay a $300 fine in that case and to follow all of the rules and conditions of probation. One of those conditions in each case is, again, that you enter and successfully complete the cognitive track of the ISF program. Also, there's going to be you're going to have a couple of assessments done just to see what all probation needs to offer you so that you can be successful. There's going to be a mental health evaluation.
What the judge is offering here is actually a massive opportunity. Deferred adjudication means if he completes probation successfully, he avoids ending up with a felony conviction on his record that can change the entire trajectory of someone's life, jobs, housing, future opportunities, all of it. But listen carefully to the flip side. One violation, one bad decision, one incident report, and suddenly he could be staring at years in prison instead. The pressure in situations like this is enormous because the court is giving freedom with conditions attached.
Substance abuse evaluation, and if there's anything in those evaluations that say that you need some further treatment for whatever it is, then it is going to be your responsibility to do that and part of your probation. Do you understand?
Yes, ma'am.
You're going to get all the tools that you need to be successful. You're young. You don't have felony conviction on your record right now. If you successfully complete these probations, you will never have a felony conviction. This is a great opportunity. But the other side of that is if you violate any condition and you don't take advantage of the tools that are going to be given to you to be more successful, you're going to be right back in your court. You're going to be looking at up to 2 years in the state jail prison in one case, and between 2 years and up to 10 years in prison on the other. You understand? Again, I want to make sure I reiterate how important it is not to get in trouble in jail while you're waiting on ISF, and not to get in trouble while you're at ISF. If other young men are out there acting up, you need to say, look, I want to see the light of day again. Y'all go do what you're going to do, and I'm going to today sit on your bunk when you're supposed to sit on your bunk. Don't sit on it when you're not supposed to. Have whatever you're supposed to have. Don't have extras. Just follow the rules. And if you're called out for not following a rule, don't get mad at the person that's calling you out for not following the rule, right?
And honestly, this may have been the most practical advice in the entire hearing. The judge is basically telling him survival in programs like ISF is about discipline and avoiding group chaos. Courts see it all the time. One person gets dragged into somebody else's bad decisions, and suddenly their probation is gone. The don't get mad at staff for enforcing rules part is especially important because disrespect toward officers or staff gets documented fast, and those reports come straight back to the judge. Would you be able to stay completely focused in an environment where everyone around you might be acting reckless?
You're the one that's not following it, so don't get mad at them, okay? I'm handing you in each of your cases the trial court certifications that shows these were agreements that I followed, so you have waived your right to appeal. Good luck to you, sir. I hope you do well.
Thank you.
Good morning, sir. Are you Derek Ardwan? And will your client waive the formal reading of the indictment? Mr. Ardwan, in cause number 250350, you're charged with the second-degree felony offense of sexual assault, and that's from July 15th of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney, you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a cap of 6 years in prison, which means if I accept this agreement, you're leaving your punishment up to me. And I cannot give you more than 6 years. I could give you 6 years.
This is where the stakes suddenly get much higher. Unlike the earlier cases, this plea deal comes with sentencing cap, meaning the judge has major discretion here. She could go lower or she could go all the way to 6 years. And when a defendant gives up the right to a jury trial, they're putting an enormous amount of trust in the court's judgment. That's a gamble not everyone is willing to take, especially in a case involving sexual assault allegations, where sentencing outcomes can vary dramatically depending on the details presented later.
I can give you less. It'll depend on the information that's brought to me at a sentencing hearing. You have an absolute right to have a jury come in and determine 2 things. The first is to decide if you're guilty or not. And then if they find you guilty, you can leave.
This is where the stakes suddenly get much higher. Unlike the earlier cases, this plea deal comes with a sentencing cap, meaning the judge has major discretion here. She could go lower, or she could go all the way to 6 years. And when a defendant gives up the right to a jury trial, they're putting an enormous amount of trust in the court's judgment. That's a gamble not everyone is willing to take.
You can leave your punishment up to them. If we go forward this way, you're waiving that right. And is that what you want to do? Also, do you understand that if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Also, as a result of this plea, it looks like you have gone over with your attorney that you will.
That ending leave the entire case hanging in suspense. No final sentence yet. Just a reset for a pre-sentence investigation where probation officers dig deep into the defendant's background, behavior, and history before the judge makes the final call. These reports can seriously influence sentencing outcomes because they often include victim impact information, criminal history, psychological evaluations, and recommendations to court. So now the big question becomes, will the judge ultimately see rehabilitation potential or continuing risk to the public?
Be required to register as a sex offender, and looks like you've already signed that document and those admonishments. Is that your understanding as well? State tenders number 1.
No, Judge.
It's admitted. Is there any evidence that Mr. Ardwan is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Lewis, and he will present it to me on your behalf when we come back. All right? You can go back with the bailiff.
That ending leaves the entire case hanging in suspense. No final sentence yet, just a reset for a pre-sentence investigation, where probation officers dig deep into the defendant's background, behavior, and history before the judge makes the final call. These reports can seriously influence sentencing outcomes. So now the big question becomes, will the court see rehabilitation potential or risk?